Oh, I'm freezing. Okay, there we go. All right. So this has been quite an interesting case. I spoke with the Chief
You gonna
Justice.
shout?
Oh, yes. Is that better?
Yeah.
Okay. So this has been quite the interesting case. And I spoke with the chief, of course, and making sure that allowances are being made for the fact that, this case has been thrust upon us all, and not only that, we're also trying to learn the new processes of being in this new city, with the exception of Miss Bella.
Can you repeat? Because you was breaking.
Can you hear me okay now?
Yeah, you're fine.
Okay. Your mic is going in and out.
Fine.
Yeah. So that could be a little bit of it too. Oh, shit.
Okay, is it better?
Ah, a lot better. Yes, 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 a lot better.
Yeah.
All right. So what I was saying was that this is a very interesting case, and it's all been thrust upon us, and we've had very little time to get the facts of the case together. We want to definitely allow for fairness and make sure that everyone, including myself, is up and understands the laws here in this city, as well as they make sure that they follow California law as well. So I have a couple of ground rules and as well as a decision on the motion. So to begin with, we were first given a settlement by Bella's side for Miss Noir, asking for a specific amount for a settlement. That document was a settlement document, and to which point the Dante, the Bean Machine, the defendant, rejected the offer of settlement and also agreed to go to trial. So that's where we're at right now. I have requested that the official civil suit be provided by Bella, by the plaintiff's counsel, which has been provided. Ike, have you had a chance to review that settlement? It's in the ticket, in the case filing.
Yeah, I saw it. I amended my motion to dismiss the numbers with what she put on there.
Okay. If you would do so now, you can present your motion to dismiss since everyone has now reviewed it and you have made your amendments. You can approach.
And I have a lot of documents in my pocket. Give me 2 seconds.
No worries. Take your time.
I think you have to come closer to me to get a copy.
Your Honor. So with
Yes.
this motion, my client did go to the police station and request and put charges and an arrest warrant out for Dante as well as Elizabeth, but the chief told the officers not to go through with it.
Okay.
Part of the
That's-
reason
You have the
there's no
criminal files, criminal charges as a ask should you win the case, that charges be brought.
Oh, I had to do it, yeah.
Right, and that is the appropriate way to do it in this circumstance. Every circumstance is different, but here is what we have to work with. So, Ike, we're ready to hear your grounds for dismissal, if you're ready to provide. I'm also going to pull it up so I can look at it.
Yeah, I can
This
hand you a copy, but
motion is stating, like, is the price that's on this motion is the amended settlement. This
correct.
motion is not updated.
I just updated this yesterday when y'all said the numbers were different.
Okay. All right. So right now, let's not put too much into amounts, and here's why. You can ask for any amount you want to ask for. This is not a small claims court, and it's not a government case. But the amount that you get will be determined by the courts. But you can request whatever you want to request. That doesn't mean you're going to get it, right? Right now, we're dealing with the facts of the case, and that's what we're looking at. The numbers will come later if the case is proven or not.
Where I do understand that, I just was one, like, if the document is outdated or inaccurate, I was just, that's all I was questioning.
No, whatever the numbers are, we still have the same motion to dismiss. That's what she's saying.
Understood. All right. So, Ike, if you can let Bella and I know the grounds for your motion to dismiss.
Well, sufficient probable cause hasn't been established for any criminal or civil in this matter. We have evidence to be outlined in our court argument, in this argument now that I'm presenting, that proves the innocence of our client with this evidence. I just ask that this be dismissed because our client is not liable for anything that happened to Ms. Noor. I forgot how to pronounce it. I'm sorry, Noor. Nothing that happened to her was Beam Machine or Dante Foster's fault.
Okay.
I have evidence statement stating that Miss, call her because I don't know how to pronounce her last name.
Noor.
Miss Norris work. Miss Noor was headed to the Beam Machine in order to meet with Dante. This statement I have from this specific witness also says that he didn't know that Elizé was also attending the meeting because the meeting was scheduled between Noor and Dante from his recollection. He said he heard the two of them in the office discussing it before he heard the gunshot and seeing Miss Elizé running out.
No, that's not what my client. No, that's not my client's story. My client's story was that he was there in the meeting, saw her get shot, and then he tried to save her.
That is your client's story. This is from a witness that was working at the time.
That sounds like hearsay. The witness is not here. So, per the facts of this case, Dante was in the office, had a meeting that Elizé was also a part of somehow, and Elizé off the clock did whatever she did, and after the whole situation, Dante still proceeds to try to help Miss.
I also have a statement from Miss Noor herself stating that she talked to Dante about a matter. He told her to come to the Beam Machine so that they could talk further.
Again, Nurse after she was shot was carried outside by Dante for EMS treatment because, again, he was just as shocked at the situation as everybody else was. So, again, I stand by my statement that nothing that happened to Miss Noor was on the fault of Dante or
Your Honor, I will also
Machine.
like to state the fact I have another witness stating that Elizé and Dante had a conversation on putting money on the heads of Shiloh Gray and Jabari King so that they do not testify in court if this matter was to go to court. I also have a witness stating that as well.
Again, I don't see these witnesses anywhere, but again, that's hearsay.
I did submit a witness list that these people will be testifying in court should this matter, when this matter go to court.
Your Honor, I also have evidence in the handbook of Beam Machine that states any employee off the clock is treated as a customer and should follow customer guidelines. Also, in this same handbook, it states that any disrespect between coworkers will result in loss of job, which is why Alize Castillo also does not work for Beam Machine anymore.
Was she fired?
That is not the reason
I have
why
a- I have
Alize
a-
does not work
She
for
was
Beam.
fired pending.
Hold
She
on,
was
you
fired.
two. I have a clarifying question. Was she fired before she was shot or after she was shot?
Nurse was fired before she was shot. Alize was fired after
Correct.
the
And she
investigation
was
of the
fired
situation.
she was fired.
She was fired about 30 minutes before that. I have a again timestamp of the actual second that she was fired, the moment she was fired.
It was still during the meeting. Called her
What,
to.
what time were
May I-
you like? What time? Give me a time. You're saying during the meeting.
Let me state this. Dante called not Eliza, excuse me. Dante called Miss Orr to have a meeting, calling her directly, the Beam Machine.
That meeting was said to be by her request.
Point out the
And
definition
so
that
he set
aiding
up
and
a,
abetting
One at a
means
time.
providing the kind of help or encouragement that would allow someone to commit a crime. So luring is a direct act of aiding and abetting. Calling
You
her
have
to
to
the
have-
Beam Machine in order
you
to
have
have
to
a
have
meeting
definitive
that
proof
she
that he
had
was
no
luring,
knowledge that
not that
Miss
he called her
Eliza
to
was
the
going to
Beam
be
Machine.
present.
So you have to have some kind of proof that he had foreknowledge that she was going to do that for it to be aiding and abetting. And I'm
No,
1,000% sure you
he
don't have
does
that.
have to have full knowledge that she was going to be doing that.
Actually, she does if it's aiding and abetting. He's aiding the crime, and you
Unknowingly
can't
be
aid the crime not
accessory
knowing.
to.
Yeah,
Yes,
that's
you
not
can.
the same thing.
Yes,
That's
you
not
can.
the same thing. Those are two different charges you're
Most
talking about. One.
definitely could
All right, I'm
unknowingly
not
be
arguing with you. I know the
accessory
law.
to a crime.
Anyway,
Okay.
that's
The law
All right,
teacher.
guys,
We
so
both
I'm
lawyers.
ready.
We both have our bar card.
So if you two are done, I'm ready to let you know what I've decided. First, let's look at California law, right? In California, a employer can be held liable for negligence if they owed a duty of care, if they breached that duty, and that breach caused injury or death. I'm citing case Rowland versus Christian, California. The owners are also responsible for the safety of individuals. Both of you have to prove your case based on California labor law. The fact that they were on the clock or off the clock, California law basically does not care about that. Did he have a duty of care, and was he negligent in his duty of care in this space?
Yes, Your Honor.
If there was a wrongful death, please look up the California's wrongful death statute. The family of a deceased person or an injured person, they can bring suit if the other party was negligent. So in this case, was Dante negligent in his duty of care according to and by California labor laws, which is basically what this argument is about.
Again, that's where I would say she has to prove that he had some kind of intent behind it, or there was that he was being negligent, like you just introduced, and neither are true. He called
Okay,
a
so
meeting
that's something.
where
Hold
it's at the time.
hold on. Now that is something to be argued in court. But now let's look at the motion to dismiss. You filed the motion to dismiss.
None of the
You filed a
yeah,
motion.
none of. Go ahead.
You filed a motion to dismiss the wrongful death claim against Dante, citing a lack of arrest and insufficient probable cause. Is this correct?
Right.
Right. So the court finds that this is a civil matter, not a criminal proceeding. Civil liability does not require an arrest or criminal charges. The plaintiff has met the civil burden of pleading with sufficient facts to proceed under the standards of duty, breach, causation, and foreseeability. Therefore, the motion to dismiss is denied. The case shall move forward in civil court.
So you're saying that there was sufficient evidence on that side to implement my client in this case?
There
Because that's what I
is,
made the motion to dismiss based off of. And I still
your
would say
motion to dismiss is based off of citing lack of arrest and insufficient probable cause. This is a civil case,
correct
not
for all
a,
matters.
this is a
For all
civil,
matters.
this is a civil case, not a criminal case.
Correct. Well, I'll also
Right. Civil
attack
liability,
the
hold
civil
on.
matter.
But civil liability does not require an arrest or criminal charges, and also he can defend himself and prove that he was not negligent in his duty of care. The plaintiff is alleging
He can
and
prove that
charging.
he was very much negligent.
Hold on. The plaintiff is alleging that he was negligent of his duty of care as per the California labor laws. That is what this case is about. She has proven and provided enough detail in her complaint that will allow for her to proceed with her civil case and confront Dante in regards to these charges. Or to this suit, rather, not charges, that's criminal, sorry, to this suit. Each side must prove that they did not break the law in that space. An employer can be held liable for negligence if they owed a duty of care, if they breached that duty and that breach caused death or injury. Employers in California are always responsible for the safety of individuals especially when they insert themselves into a situation that carries a clear and present risk. Each of you have to prove your case. Bring witnesses, statements, videos, whatever it is. Now, to that end, Bella, the video that you provided us will not be allowed into evidence. The state of California, as well as District 10, is very clear about the ways in which body cam footage can be presented in court. We have received clarification on this, and therefore that video footage will not be allowed. You will have to prove the death of your
Your Honor,
client.
I'm still fully prepared
Okay.
to take this matter to court and win it.
Okay. You'll have to prove the death of your client another way. If you cannot prove that your client died, there's no wrongful death. So both of you have
As stated earlier, I do have witnesses that witnessed one witness came in. He stated he heard
Save it for
Dante
court.
and he heard Dante. Okay, I'll save it for court.
Save it for court.
Your Honor, I do want to also be clear that a lot of the witnesses that I have testifying, they're afraid of Dante retaliating and firing them. Some have stated that he retaliated and fired multiple other employees for them giving their opinion on how the job was being done. And they don't want that to be their same fate.
The court does sympathize with it. The court definitely does sympathize with the employees, but we hope that now having a functioning DOJ, people will also have recourse to hold those accountable and that justice can be served. I think that Dante should also have a space in which to speak up for himself. He has the right to defend himself even against, folks saying that they are scared of him and things of that nature. You guys have a great case to prove. Both of you have a lot to prove. It is a great case, and it is mired in California labor law. So make sure that you review those statutes and understand
Your Honor,
exactly
I do have a
how
question.
it relates. Yes.
I did put in for those policies to be produced to me that they were bringing up at our last hearing.
Yes,
The Bean Machines work policy.
I will submit and I will approve your subpoena to have those files or to have that handbook provided to you, especially if it is used as a basis for the defense's defense.
Thank you, Your Honor.
Are we not? Does my discovery not count? That's part of my discovery.
If it is a part of your
That
discovery,
the
the other
handbook is a
side,
part of your
the
discovery?
the other side
Right, but
must
I don't have to
also have
produce that to her
access.
until right, not yet though,
I
right?
mean,
It's not a
if
trial.
it's gonna be used as evidence or anything pertaining to this case, I need
Correct, and you will have it before trial.
She can, on her
every
own, request those files as well, or it is up to her. She can wait for it to be introduced into evidence, which is literally like right around the corner.
Right.
It's up to her. But you guys should be, that ticket
See
should be
now.
where, you know, you're placing all of these things. Will definitely make it a little bit more organized within that ticket.
Wait, where? I was told that we have our own personal discoveries until we present them.
Yes, you should have your own personal discovery. And then when it's to be presented, it will be put into the same space so that everybody has access to what everybody else has. Same way, the same way we used to do it before same rules apply. But if she would like to move forward and subpoena records, that is her right to do so.
Yeah, I'm gonna be moving
Have it.
forward to subpoena those because he's not trying to let me see them.
Don't
Let me
even
know.
worry about it. She just said it, so you'll have it right after this trial.
Okay.
Don't even waste your paperwork.
Okay. All right. So Ike has agreed to provide you the handbook right after this hearing has concluded, and then we can go from there.
On the subpoena, I stated that I need all legal documentation pertaining to the Beam Machine's employment. So I need the handbook as well as any policies that they have in place for employer.
They're all outlined in the handbook.
All right.
Okay, thank
So
you.
Bella, once you receive the handbook, if it's not sufficient and you feel like you need more information and documentation that you know the Beam possesses, then you can move forward with your subpoena. Until then, let's act in good faith that Ike is going to provide you the documentation that you have requested.
Your Honor, with the witness statement, can I don't mind typing this information up, but I do have 2 witnesses who were working that day. So can I also have a subpoena for that office footage from the Beam Machine to be produced?
You can make a request, yes, and I'll review it.
Yeah, that one you have to go through your paperwork. Those are private files for the Beam Machine owners only,
Yes, you can.
not employees, not regular employees.
You can subpoena the security cam footage of the
This is a
office of
legal
that day.
matter.
I understand, but it's also his private files.
Which can be
This is still a legal
hold on,
matter.
guys, hold on. The video files can be subpoenaed. Okay, so if there's something that you want, make a request for it, as long as it is within the scope of this case. Meaning you can only ask for files of the
I gotta
security
think about
security cam that happened in that office during that time. Okay? All right, are there any other questions? Now let's talk about scheduling for this case. Would you guys like to begin this, let's say, Thursday? If we could get started with the evidentiary hearing? If we could get back to the evidentiary hearing? Because
So
if
today was just a motion.
today
We're not
was
gonna go.
today was just the motion.
Well, she has more evidence because she's presenting that. I'm only going to present defensive evidence. So evidence against what they're bringing. So that's when I'll enter.
I was
evidence.
told that both sides would have liked a little bit of additional time just to dot T's and cross I's.
Oh yeah, I mean, if more time is being asked for, that's different. I thought we were just. I'm good to go. That's all.
Okay. All right, so maybe
Okay,
we can move it up
I'm back
to.
focused.
Okay, So maybe we're talking about scheduling and talking about if we can proceed with the evidentiary hearing on, I was gonna say Thursday, but if everybody's, just needs a little bit more time, we can go to Wednesday. If you need more time than that, then I can push it back to Thursday.
We
That
could
works.
actually do Thursday is fine because I still got to get these.
Okay. All right. So we'll do Thursday at 6:30 p.m. All right.
Cool.
Now, for your
Work on that now
witnesses,
to
if your
give them time
witnesses
to
are not, if your witnesses cannot come to court, remember, please video them, get body cam footage of their statements, upload it to YT, to Utubobia, whatever we call it here, and that way we'll be able to have access to it, okay?
Yes, ma'am.
If you need help with that, make sure you grab a paralegal that can do that recording and the uploading for you.
Yes, ma'am. Yes.
Okay. Is there anything else?
For us from my side, not at this time.
Okay, Ike?
Yeah, it's good.
All right. I will see both of you on Thursday at 6:30 p.m. We move forward with the remainder of the evidentiary hearing. We're
Will
adjourned.
do.
Thank you, guys.
All right.
Y'all be safe.
Guys.
Lord. Hey Harlem, I'm gonna try to get my sound fixed as soon as I can. I know, I'm on a new mic. My mic acting up, honey. All right, I'll see you guys later. This case is going to be a good one, definitely a doozy.